Okay, we're going to get started again. If you missed me, don't fret, because you're going to get me for back-to-back sessions now, so I hope you enjoy. My first topic I'm going to talk to you about today is the hashtag #MeToo movement. Back in October 2017, which seems like a lifetime ago, but it was really less than a year and a half ago, Alyssa Milano gave her famous tweet where she called on victims of sexual harassment and assault to include the phrase "Me Too" in their replies to that. And the results, suffice it to say, have been overwhelming in that time. Countless executives, politicians, celebrities, from Harvey Weinstein, which triggered the initial tweet, to Louis C.K., to Al Franken, and Les Moonves, Bill Riley, I mean, you name it. The last I looked at one of these lists of famous people who have been accused of sexual harassment since then, I think it was in the 200s or so. There are websites out there that track these things, and it's been astounding, to say the least. I think reasonable minds can differ about the effect and where things stand, and whether things have gone too far or not far enough, whether we should automatically believe victims or the alleged, and whether there should be a case-by-case evaluation. Those things can all be debated, but I think the one thing we cannot debate is that sexual harassment is wrong and has no place in the workplace. And if anything has been revealed by this movement over the last few years, it's that this problem was pervasive. That there is no doubt that what we've seen come out is that this has been a real problem that has not gotten enough attention, and finally it's seeing the light of day, and it's getting the attention I believe it deserves. Some facts on sexual harassment, and as a bit of a teaser here, these facts were actually listed in a footnote in a decision out of the Third Circuit recently, which I'm going to discuss it in a moment. And so the court in that case actually looked at some of these and specifically referenced these issues. So I think these are important facts to give you a backdrop. According to a poll, this is at the same time that the movement was starting, half of all women had suffered unwanted sexual advances from men. 30% had experienced these issues at work, and 25% of all women had experienced those issues at work from a supervisor. That's pretty startling. That's 1 out of 4 women have been put in a situation that they should have never been put in. And that is a wrong that needs to be corrected, and hopefully we are on the path to doing so. According to the EEOC, if you don't know, issues statistics on a year-to-year basis, looking back over things that have happened over the past year, and discussing every couple of years they discuss their initiatives. Coming up later, we'll have a discussion from Dana Hutter from the EEOC, and I'm sure he'll mention some of these things, and so we all look forward to that. But for purposes of this, the most recent EEOC study, this is the 2016 study, found that 75% of women who had suffered workplace harassment never actually reported it, out of fear, feeling uncomfortable about it, but for whatever reason did not disclose or report that harassment. The impact on this movement, when this first happened, I think those of us in the employment law or HR world were like, yeah, this is going to be crazy. I mean, as this stuff comes out, what's the effect of this going to be? And I think we're already seeing it a little over a year into it. And it's been reflected in EEOC filings. As I mentioned, the EEOC issues reports every year, looking back on the prior year. According to the latest one in October of 2018, claims or charges filed alleging sexual harassment were up 12% from the prior year. That's a pretty dramatic number when you think about the number of claims that are filed nationwide. And also, the EEOC tracks how much they recover for victims of all types of discrimination that are filed with them, and had reported in 2018 they recovered $70 million for victims of sexual harassment, which was up a little over 22 million from the prior year. So as you can see, this is a pretty significant figure. I can also tell you anecdotally, as somebody who defends discrimination claims, the value of these claims has changed. When we dealt with these claims 3, 4, 5 years ago, you'd look at it when it came in, you'd do the typical evaluation, see what the case is worth for settlement purposes, all of that. I've seen in a lot of these cases, depending on the allegations that are coming out, I tell my clients double what we thought about before. And that's not unreasonable. I think there is a significant risk. A lot of these cases have not worked their way through the courts yet to jury trials since the movement has started, but those that were already in the pipeline, we're seeing bigger and bigger jury verdicts. And so I think the risk to employers is significant when you're looking at valuing cases for settlement purposes. One of the biggest cases to come out in light of the Me Too movement started right here in the Middle District of Pennsylvania, and then went up to the the Third Circuit, and the Third Circuit issued a decision just last year. It was Minarski versus Susquehanna County. The background facts of this case are unfortunately all too common, but are worth discussing. Ms. Minarski worked in, I believe, the 911 center in Susquehanna County. In that role, she reported to a supervisor named Yadlowski. Minarski and Yadlowski, you're up in the coal region with that, right? The two of them worked in a relatively isolated area where others weren't around very often, and Ms. Minarski was or alleges to have been subjected to some pretty severe sexual harassment. Propositions on a regular basis to engage in sexual acts. Mr. Yadlowski routinely hugged her and other women, and these weren't friendly hugs. These were the kind of creepy ones where you kind of hold it a little too long. This was pretty gross. And then I think that the cherry on top was that every Friday, instead of just saying have a good weekend, Mr. Yadlowski would forcibly kiss her on the lips. Gross. But nevertheless, this went on for about 4 years, this harassment. And finally then at the conclusion of that 4-year period, finally enough was enough, an incident happens, and Ms. Minarski reports it. At that point, Yadlowski was terminated in response to the report, and Ms. Minarski files a claim. The case goes through the EEOC, works its way up to the Federal District Court for the Middle District, and there the employer asserts a defense under Farragher and Ellerth. Farragher and Ellerth are a tandem of Supreme Court cases that laid out an affirmative defense that employers can raise. The affirmative defense has two prongs. First, the employer has to show that it undertook reasonable efforts to prevent harassment in the first place. And then secondly, that the employee failed to avail herself of those reasonable efforts prior to the action happening. So in other words, you have a policy in place, you take some efforts to prevent harassment, the employee doesn't report it. When the employee does report it, you take a prompt remedial action. That should be case closed. The employer at that point can say, look, we don't have respondeat superior liability anymore. We've done everything we could do to prevent the issue from happening. Employees will do crazy things, and that's it. The district court looked at that and said, yeah, she didn't report it. There was a 4-year period where she did not report this harassment. What's an employer to do? Once it was reported, then they took some action. And so the district court grants summary judgment. Well, the case goes up to the Third Circuit. And the Third Circuit's like, well, let's take a look at this. The Third Circuit looks at it and says, wait a second. This Farragher-Ellerth defense that you want to raise, there's a reasonableness component to it. It's not just that you have adopted a policy on the first prong. It's not just that you have a policy in place that says, hey, you can't sexually harass people. Let's look at what the policy's effectiveness. And the court looked at it and said, okay, you had these policies in place. And the policy said, look, you can report it to a commissioner. You can report it to the chief clerk. You can report it to HR. And so let's look at whether the employee engaged in any of that conduct. Well, it turns out the employee here had actually made an initial report 4 years prior when it first started happening. She had made a report to a commissioner. And that commissioner had also been sexually harassed by this same guy. So the boss of the sexual harasser had been harassed by the sexual harasser, and nothing was done about it. And so instead of actually correcting the behavior 4 years prior, that commissioner says, well, yeah, it's just him being him. He did it to me too. So the court looks at that and says, wait a second. I mean, what if the employee who's reporting this reports it to how they're supposed to, and the response is, well, yeah, it's just boys being boys. Why should the employee think that if she does report it in the future that anything would be done about it? Additionally, the employee alleged, and there was some evidence prior to summary judgment that said that the employer knew about this sexual harassment in other circumstances too. That the harasser had done his groping, hugging routine with a whole bunch of women in the workplace. And on one occasion, the plaintiff in the case indicates that she watched this happen in the view of another supervisor who then, after the gross hug thing, looks at Yadlowski and says, hey, I thought you weren't supposed to do that anymore. And they kind of had a chuckle about it. And so the court looks at that and says, again, we're looking at your reasonableness of your policy and the reasonableness of the employee's actions. And if the employee sees that and says, well, I guess that response to the initial complaint wasn't very effective, if they're just going to chuckle about it. And so also then, the court looks at the second prong. The second prong is, did the employee unreasonably fail to avail herself of these procedures? The court looks at the fact that the employee knew all of this was going on, knew that it had been reported by herself and others in the past and nothing had been done about it, and also the fact that she was a single mother and was relying on this job to put food on the table. And Mr. Yadlowski, as Ms. Minarski alleged, Mr. Yadlowski had told her that. He said, hey, you know better than to report this to HR. He had hiring and firing capabilities over her, and so she took that as a threat, that if she went forward, he would take action against her. And while she may have had a claim, if that happened, she knew she needed that job to survive as a single mother. And so what the court said in a decision issued by Judge Rendell, and I did put in your books, you have this, I didn't put the slide up here. Don't all read it at once. I guess that's you shouldn't tell people during a presentation to read. There's something really important. You should read this lengthy slide I put in there right now. But take the time when you get it to take a look at that slide. It's the footnote from Judge Rendell where she cites some of these statistics that I mentioned at the outset, and I think it's pretty poignant. Some of the things that she discusses in it about how this is such a pervasive problem, and how 75% of women who have suffered sexual harassment have been afraid to come forward. And in that context, can we look at the Farragut-Ellis defense a little bit differently? And it's not an automatic thing where employers don't automatically just get to slap down a policy and say, hey, you never reported it. Can we look at the reasonableness? Can we look at the facts of the case? And there, Judge Rendell, authoring the opinion, says, yeah, I think under these circumstances, a jury could find that the employer's policy was not reasonable, and the employee's failure to report it was reasonable. And if those two things could be the case, then the employer doesn't get to raise the defense. The jury decides that. And so I think that this was a bit of a game changer for those of us that defend these cases, and for HR professionals, I think, who deal with sexual harassment complaints and look to the effectiveness of their policies. And we'll talk about some of those strategies in a moment. Another big case, and this one is hot off the presses from just earlier this month, Parker versus Rima Consulting. This is the rumor has it case. In this case, the background facts are interesting. The female employee the female employee alleges in her complaint that she had recently received a promotion. A rumor starts in the workplace that she had gotten the promotion by sleeping her way to the top. In particular, that she had hooked up with her supervisor, and as a result of that, that's why she got the promotion that she got. Beyond that, the plaintiff alleged that she showed up to a meeting where the supervisor and some of the other men in the workplace were there. She was 30 seconds late for the meeting. They slammed the door, excluded her from the meeting, and has reason to believe that this rumor about her was discussed during that meeting. And other men had not been treated this way. They hadn't been shut out of meetings when they were just 30 seconds late. The court, on a motion to dismiss, the district court looked at that and said, well, you know, the issue here isn't really her protected class status. It's not her gender. It's really an allegation about her conduct. Her conduct of being promiscuous, and really that's not an allegation that she was discriminated against because of sex. And the court grants the employer's motion to dismiss. Fourth Circuit, yeah, they're not having that. Fourth Circuit's like, really? You're going to look at that and dismiss that and say that that's not because of her sex? Well, let's take a look at why it's not because of her sex. The allegation here, and I've included some quotes from the case. These are direct quotes. I think, again, these are pretty poignant and spot on in this analysis. And it goes to stereotyping. And this is really, I think, where we're seeing a lot more cases arise. I see them coming across my desk with internal complaints when I'm talking to HR directors, with defending the cases when we get them in EEOC charges or in court filings. And really a lot of it stems from gender stereotyping. And that's what the court addressed here. They said, wait a second, look, I mean, you are continuing this long-held belief that that the plaintiff's womanhood is what got her the position, that she had to sell herself and essentially become a prostitute to get her way to the top. I mean, that's shockingly bad, that allegation. And so, for a court to say that that's not because of sex, that that's not because of her gender, ignores the fact that that very allegation is based off of a long-standing and incredibly repugnant stereotype. And so, in looking at those allegations, we can't dismiss cases like that. I mean, that's an issue where she should at least have her day in court to be able to show that these allegations were severe, these allegations were pervasive, that this is not something that should just go unchecked. that if these types of rumors and harassment are perpetuated in the workplace, that's going to set us back instead of moving us forward to a place where men and women are treated equally in the workplace. So in light of these decisions and the movement in general, and as I mentioned, the rise in these claims, if you're an employer, you're sitting there, well, what do I do? What do I do about all of this? I think that the first step, and this is almost a direct takeaway from the Minarski decision, is ensure you have an effective anti-harassment policy. And what do I mean by effective? I don't mean just putting a lengthy, wordy definition of sexual harassment and 2 pages that some lawyer drafted with a bunch of legalese and in a handbook somewhere, having employees sign off on that the day they start and never see it again. I don't think that's going to be effective. When we defend these cases, I routinely, when we go down the road of a fair trial defense, when I get an employee in a deposition, I say, wait a second, here's the employer's policy about reporting harassment. They say, I've never seen that. So wait a second, here's your signature saying you received it. Yeah, I've never seen it. Or I didn't know what that meant. That was just, look at that. I was handed a book this big, and my first day, I never read that. How was I supposed to know what that meant? And so the more effective approach here is to have these conversations with employees at the outset of employment, and then in routine trainings thereafter. But when you sit down with them at the outset, make sure you have a anti-harassment policy that's written in plain English, that doesn't need a JD to transcribe it, that employees, your rank and file employees, are going to understand. Make sure that they understand who you're reporting to. I have a case right now. I won't get into too many details with it, but one of the allegations, we're raising a fair trial defense, and the employee is saying, yeah, you told me who the position was that I was supposed to report to, but I didn't know who that was. This is a big employer. I didn't know who the person that held that title was, and so make sure the employees know. Okay, here's don't just say, hey, you're supposed to report it to HR. Say, here's the HR department. Here's a hotline. If you have a hotline, fantastic. That's a great step. But if you're a smaller employer and you don't have those capabilities, clearly define who they're supposed to report it to, address, phone number, put all of that in there. Make sure they understand that. Make sure there's an alternate reporting procedure as well, so that if the alleged harasser is the person they're supposed to report to, that's not going to get you very far in asserting a fair trial defense. And make sure those procedures are in place and that they are followed up on. That if you have these procedures in place, if you get a report, you are consistently following up on them. You are taking steps to immediately assess the situation. Hopefully you're getting outside counsel on the phone right away and saying, hey, what do we need to do here? Do we need to separate the employees temporarily? What do we need to put people on paid leave until we can sort this out? What are we going to do? Make sure you're doing that consistently every time. You're not letting some allegations slip because, hey, this person's a frequent complainer. I'm not going to deal with that. She's always griping. I'm not going to deal with that. Deal with the allegation every time. Be consistent. Hold people accountable too. If you have investigated the allegations and there's some merit to it, or might be some merit to it, take some appropriate action. I'm not saying you have to terminate someone every time there's an allegation of sexual harassment. That is not the standard. The standard is that you take precautions that are reasonably calculated to prevent future harassment from that harasser. And so if it is counseling, coaching, refresher course, disciplinary actions like a suspension, last chance warning, those things are all appropriate measures. These things are determined on a fact basis, case by case basis, that you have to look at this and say, what's appropriate here to stop this? If this guy really did this, what's going to stop him from doing this in the future? Also, with training, and this one is fundamentally important, make sure you have real training. I know a lot of employers will say, yeah, we have some training, we have somebody come in, employees sit down and they watch some ancient VHS video on a little tube TV, and that's in the break room when they start here, and that's our training on sexual harassment. That's not going to be effective. And in looking at these trainings, I think the best practice is to have separate training for your rank and file employees and your supervisors, because the issues for the two different classes of employees here are important. Your rank and file employees, make sure that you're not just pounding definitions of what harassment is. You're not just saying, here's the legal definition of sexual harassment, don't do it. Go through some real scenarios, some role playing, some things to make them realize that treating each other with respect is really the main goal here. With your supervisors, make sure they know what to look for. If they see something, they're doing something about it. That if somebody comes to them, that they know what to do, that they know when to loop HR in early and often, that they're looping HR into these situations. And that when you're training your supervisors, the other thing to look for is in your processes. Again, the stereotyping that's involved in your decision making. I mean, that's I think a crucial factor with your training with your supervisors. When you're sitting down with them and talking about discrimination, I mean, when you're evaluating an employee for a promotion, if you hear something if your supervisor ever says something along the lines of, well, she's pretty good, but she's already had 1 or 2 kids, I think she's going to have some more, and so, Bob's really more of a team player, and we can count on him more for the next couple of years. If you have a discussion like that during a promotion decision, you're in trouble. Not just from a legal perspective, but that's not the kind of workplace anyone wants to work at. You're going to lose talent that way. The times have changed, and that's just not acceptable anymore. I mean, that type of stereotyping that goes into decision makings is just wholly unacceptable. And so your supervisors need to be made aware of that. For some of them who have been there for a long time, that may be, hey, it's just the way things are, or I'm keeping it real. I'm telling it like it is. But that's not the world we live in anymore. And I think maybe most importantly in all of this is buy-in from leadership. Your leadership's focus should not necessarily be on compliance. Compliance is great. You want to make sure you're not getting sued, of course. But if you have a leadership that is committed to providing a workplace that's free from discrimination and harassment, and fostering a workplace where everybody treats each other with respect, that's going to in turn lend itself to compliance. I mean, that is, if you can foster that type of environment, these other things don't happen because they become unacceptable. If you have a workplace where everybody's committed to doing the right thing, when somebody does the wrong thing, they're going to get called out for it. They're not going to chuckle under their breath about somebody doing the wrong thing. They're going to ostracize the harasser, and that's what you want. You want the workplace where the harasser is the one who's ostracized. Before I wrap up on this, I will put it, and I'm sure he's going to mention it as well, as far as training, the EEOC, Dana Hutter's probably going to mention this as well, but EEOC has a fantastic program. They do their own sexual harassment trainings. For years, they kind of did the more traditional training, and now they have a Respectful Workplaces training program that is fantastic. It's also very cost-effective. The cost for that is probably less than I've seen some other outside companies doing. So I would encourage you to consider that if you're going to bring somebody in from the outside, if you don't have the in-house capabilities to do it, certainly consider that. Briefly though, before I flip into my next presentation, I'd like to introduce Mark Hamilton from our firm's Pittsburgh office. Mark has a pretty unique role. In addition to being outside defense counsel, Mark is also the solicitor for the Pittsburgh Human Relations Commission. In that role, Mark has had the opportunity to be on kind of the cutting edge of some developments in pregnancy discrimination, and Mark asked to give for me to give him a few minutes here today to kind of give a pitch on that and let you know where things are developing in that area of the law, which is certainly an interesting and developing area of the law. So I'm going to turn the mic over here to Mark for just a few minutes. You hear that, Mark? Just a few minutes.
I heard that.
Yeah, clearly my biggest challenge this morning was not getting from Pittsburgh to here by 8:30, but rather keeping this to 2 minutes. Now, what lawyer can talk in 2 minutes? So I'm not even going to listen to that, but I'll keep it under 5 for sure. So good morning, welcome, and I just wanted to talk to you briefly about some issues that I think are developing on the front of pregnancy. Later today, or later this morning, we'll be hearing representatives at the state level out of the Attorney General's office and Dana Hunter out of the EEOC on the federal level. And I want to remind you that we have a local level. And the purpose of what I passed out to you was just to alert you to the fact that most of our bigger metropolitan cities have Commission on Human Relations or entities similarly named. And they tend to be on the cutting edge of defining what is discrimination, how to prevent it, and protecting the rights of employees. I listened to my partner David Schwalm's presentation earlier, and coupled with what I'm about to talk about here, I will make one observation that any legislation that has in its title fair or fairness in it, it probably is a red flag for an employer. I heard about the Fair Work Week legislation, and I'm going to talk very briefly about Pregnant Workers Fairness Act out of New York. And, you know, saying that I've always believed in, reality and perception, and what's fair to perhaps an employee may not be fair or equitable to an employer, but as representatives of employers, insurers of employers, it is incumbent upon us to look at it from the employee's point of view, given the laws of our land. So what I've passed out to you real briefly is a guidance document that was published in accordance and accompanying the New York City Pregnant Workers Fairness Act 6 years ago. And that's a long time ago. But I'm not going to go through it with you. It's an additional document for you to read in your leisure. I'm going to share a few excerpts, segments with you, just to kind of clue you in as to how agencies, whether they be federal, state, or in this case local, are viewing the changing times of which Anthony speaks. It starts with a statement that the Pregnant Workers Fairness Act reflects the growing recognition that expanded protections for employees related to pregnancy, childbirth, and related medical conditions are increasingly necessary. Not desired, but necessary. Expanded protections. Okay, hallmarks of where the law in this area has been going and continues to go. I then move on a few other pages for another line out of this guidance document. Employees can now request accommodations from employers based on pregnancy, childbirth, or related medical condition, regardless of whether their medical condition amounts to a disability. Now that's a break from law of years ago, and increasingly we are going in that direction. It then expands upon that by stating that under federal law, the Pregnancy Discrimination Act of 1978 requires equal treatment for all workers, similar in their ability or inability to work. Going well beyond federal protections, the New York statute protects the rights of pregnant individuals by requiring employers to make reasonable accommodations for pregnancy, childbirth, or related medical condition, regardless of whether and to what degree other employees are accommodated. Minor or temporary modifications to work schedules, requests for temporary shift assignments, additional breaks, requests to sit during shifts, temporary unpaid leave, regardless of whether they are offered to other employees, must be granted absent evidence that such accommodations will pose an undue hardship, which is a concept that remains in effect. The Act goes on to talk about initiating the cooperative dialogue, and frankly puts a burden on it on the employer in initiating dialogue that you don't commonly see and have not commonly seen under federal law. Where are we going with this as I close out what I have to say to you? Yesterday in Pittsburgh, legislation was announced that as to a new pregnancy legislation initiative in Pittsburgh, and if adopted by City Council in Pittsburgh, will be the first legislation in the country that expands the protections given to pregnant employees, such as that outlined in the New York City legislation, expands it to include their partners. And the definition of partner is frankly a liberal one, and I don't mean that in a political sense. It's not related to someone that you may live with. It's not definitely related to someone you may be married to. It's not related to someone you may be related to. And so that's the direction that I think we're finding. The concern over discrimination related to women that are either pregnant or of pregnant age. And I think we're going to see growing legislation, especially on a local level. And it's just something that as you become aware of and keep up with the state and federal regulations, keep an eye on what's going on a more local level that may affect you. Thank you, and I'll turn it back over to Anthony.
Thank you, Mark. And that was astoundingly brief as far as Mark goes. I give you all the credit for keeping those remarks brief. For those of you who have ever seen Mark speak before, he's not shy about the mic. So thank you, Mark. So I'm going to switch gears a little bit and talk to you about considerations in settling employment cases. This is the area nobody wants to really deal with. Because if you're dealing with this as the employer or as the insurance carrier, it means you've got a case and you're going to probably pay some money to get out of it. From my perspective as the defense attorney, I don't like doing this because I want to go to trial on every case. I want to go to court and win every case. But in the overwhelming majority of employment lawsuits, settling is probably the best option and most cost-effective option. So when a case comes in, I mean, what kind of things should you be considering in evaluating settlement? The first one is, did you make a mistake? And this is more for the employers in the room. There have been times where I get a call and they say, we just got this suit, we screwed up. We took some action. We found out something later that would have changed our analysis and who we fired or who we didn't fire. We let an employee walk after raising a complaint, and in hindsight, we probably should have dealt with this differently. That's the first step here to resolving these very often, if that was the case. And there are some things we can do at that stage to try to make things right if it's identified early on. Another consideration, what's the impact outside of this case? If we settle this case, are there going to be follow-along suits? Are other employees going to see the employer as a mark, an easy target for litigation? While we can have some confidentiality provisions in these agreements, at least still today here in Pennsylvania, we can. If it's a private employer, I will tell you that there are efforts in states nationwide to prohibit employers from entering into confidentiality agreements in settlements of certain discrimination lawsuits, namely sexual harassment suits, and certain states are starting to disallow those. I believe New York has as of this moment, and certainly for any public employers, because of the right to know law, they cannot keep settlements confidential. So, if you do settle a case, are you going to be seen as a target for other employees? The venue of the case and the assigned judge, although we don't like to think that this should matter, in some cases it does. And while I firmly believe that most of our judiciary, at least in the federal districts where I practice, are fantastic judges and are very level-headed and will decide cases on the merits, I think we who practice in front of them will be able to tell you that some judges more readily grant motions to dismiss or summary judgment than others. It doesn't necessarily mean that they're biased one way or the other. They're just a little bit different in the way they analyze cases. And in light of that, are we going to be looking at additional costs? If we're assigned a judge in a certain district and we know that judge never grants motions to dismiss, we know we're going to be dealing with discovery costs. And so is that a consideration we should look at in valuing the case? In terms of the parties, the plaintiff and who our key witnesses are going to be, I think it's important to have an early assessment of what they're going to be like. I like to go out and meet with the employer immediately and interview people. And I'm doing that not just for fact-gathering purposes. I like to meet with the employer and the key witnesses in person because I want to know how people are going to look when they have to testify. When I'm sitting there meeting with them and it's a non-confrontational way, are they squirming in their seat a little bit? Does the guy come off as a prick? Yeah, those things are important because eventually that's going to come out if the case goes forward, and so we want to be aware of that early in trying to value the case. We want to look at the damages. This is difficult sometimes in employment cases where we get them at the PHRC level or the EEOC level, and we don't know right away if the employee has found other employment. Because if the employee has gone out and found another job, they've mitigated their back pay claim. That's very important many times. If there's not a strong emotional distress component to the case, we want to look at what back pay is and kind of go from there in valuing the case. And so if we can find out whether the employee got other employment right away and there's very little back pay, that's oftentimes a key component to valuing the case and discussing settlement with the opposing side. Another issue here at the bottom, and this is an issue I'm dealing with in a case that perhaps we will address tomorrow in a court mediation, but is the employee still there? This brings up it can kind of go both ways. Where the employee is no longer there, it usually becomes a money issue. Although there's the concern of follow-along suits, you're done with that employee. If that employee is still there, that employee is still under your employ, if you settle with them, are you just kind of saying, well, hey, anytime you file one of these claims, we're going to hand you a bunch of money? On the flip side of it, if you go through the litigation and you win or you lose, is that employee going to, if they win, be more encouraged to file suit again to bring future claims? Or if you lose, are you then going to have a really ticked off employee and a miserable employee? If the employee is still there, are there some ways you can resolve the claim outside of money in terms of changes in employment, transfers, promotions, things like that to put the employee in a more comfortable position that might better resolve the case moving forward? So you're not dealing with a situation in the future. Another issue that comes up very often when we get to the final settlement negotiations is what are the tax implications for the employer and employee? these cases are a little bit different than your general liability cases. So for the folks in the room who and out there in webinar land who are claims adjusters, these issues are unique from your general liability cases in terms of their tax treatment of the settlement proceeds and the attorney's fees payments. Whatever we put in an agreement, the IRS may not agree with. The IRS has issued guidance on these, and the fundamental issue is, what is a settlement in lieu of? If you're paying paying money under a settlement, what would that otherwise have been? And so, in looking at employment cases, the different types of damages that are available. Back pay, front pay, compensatory damages, punitives, liquidated damages, and attorney's fees are generally the categories of money that you're looking at in a case. And so if you're looking at settling one of these cases, what did the plaintiff raise in the case? Did the plaintiff have a claim for back pay? Did the plaintiff have no back pay claim because the plaintiff found other employment right away, and this is purely an emotional distress damage claim? And the key with that is that the tax treatment is different under those different components. If there is a portion of the settlement amount that is ascribed to what would otherwise be back pay or W-2 wages, then the employer has to go through its typical withholdings from those amounts when you're settling a case. And so that check will always have to be issued by the employer. If there's insurance involved, the employer is typically going to issue that check, and then there will be a reimbursement that flows one way or another because of that. But you're going to have to do all your FICA withholdings from that amount. If there's some portion of it that is compensatory damages for emotional distress, that amount is still income to the employee, but that can be issued on a 1099, so you don't have all of those additional withholdings. The employee's still going to pay regular income tax on that, but again, there's not those additional holdings, and you as the employer don't have to pay the employer's contributions to FICA on that amount. The court there's a Second Circuit case here that's been very instructive in these cases, and it's frequently cited when this issue comes up. And in that case, the issue was what the parties put in their agreements. And so when you're settling this case, I would encourage you to have this discussion during the negotiations, or have your attorney should be having these discussions with you and with opposing counsel. And if you are going to characterize some portion as something other than W-2 wages, that should be clearly stated in the agreement. That your explanation for that should go in the settlement agreement, that the parties reasonably, I have a phrase I usually use, the parties reasonably believe, based off the claims in the case, that the settlement payment herein is not wage loss, but represents non-economic damages. Something along those lines, because what the court in the Second Circuit said in Gerstenbluth is that the party's intent is afforded particular weight, and in particular the payor. So if there's a difference of opinion between the employee and the employer is the payor, and the agreement is silent on it, the court is going to look at what the payor's intention was and give that a little bit more weight than what the employee might have thought. However, the best practice in this is to clearly state it in the agreement, show that you've analyzed this issue, that you're not just trying to mischaracterize funds as something they shouldn't be, because the negative impact on this is if somebody gets audited and you find the IRS says, wait a second, you did this all on a 1099, the employee had a huge back pay claim. And discovery shows that the employee was out of work for 2 years and was a high wage earner. You had a huge back pay claim, and all of a sudden you put all the value of the settlement on a 1099. That's not going to hold up. And so if there are particular circumstances in the case, you should address that in the agreement. Coming full circle from the last discussion, the tax bill from last year, the Congress's revisions to the Internal Revenue Code last year included what has come to be known as the Weinstein tax. Typically, in resolving lawsuits, attorney's fees that companies pay to defend and resolve lawsuits are considered to be tax deductible. The Weinstein tax changed all of that, and now employers can no longer take a tax deduction for fees that they incurred in defending a claim of sexual harassment, or for monies they paid to settle claims of sexual harassment. So if the employer paid money to resolve a sexual harassment claim, paid its attorney's fees, the employer cannot deduct that. We don't yet have any guidance as to how that works in the context of insurance. So if insurance pays that, is the employer deemed to have to pay that amount, and is there a tax deduction there? I think that's anybody's guess at this point. This was a rush job by Congress. But one of the other things that has come up frequently more recently, I've had this with a number of plaintiffs' attorneys saying, you know, it's kind of vague in the way Congress enacted this, and it really says all fees paid. And so typically an employee's fees, so if we settle an agreement, we pay some portion to the employee. We also typically pay a separate check to the plaintiff's lawyer for the attorney's fees. And that amount is income to the employee, but the employee typically had an above-the-line deduction for that amount. So the employee ends up not paying taxes on that amount. And that much was pretty clear. But with the way Congress enacted the recent revisions and the Weinstein tax, there's an argument to be made that the amounts paid to the employee's attorney may also not be tax deductible to the employee. I think that's a bit of a reach. I think that would be certainly not within the intention of Congress. But some plaintiffs' lawyers have raised that and used that as a negotiating point to try to get some more money in settlement up front, because they say, look, you know, my client could end up, if a court rules the opposite and finds that this is the way the tax code was written, my client could end up paying more tax on the money that was paid to me, and we weren't expecting that. Some other settlement strategies. If your case is filed with the EEOC, they have an early mediation program that is fantastic. If you can get in, it's fantastic. I know certain offices, the backlog is pretty tremendous. But if your case is selected for mediation, especially in a low dollar value case, if you know you've got a plaintiff who, or charging party with the EEOC, who has very limited back pay, maybe the claim's not as substantial, even defending a simple case through the EEOC level, as those of you who have gone through it know, it can cost you a lot of money just to prepare a position statement, to interview witnesses, to collect all the documents necessary to do so. You can be looking at $5,000, $10,000, $15,000 in attorney's fees just to get to that point in the EEOC process. So if you have the opportunity, the early mediation program, you go to mediation before you incur any of those costs and before you provide a position statement. You'd still have some legwork to do to evaluate your case, certainly, but I think it's a fantastic opportunity to try to resolve cases early before you have to put anything out there in terms of a position statement. If you are in federal court, the Middle District, we have a free mediation program. And so that is very advantageous. I've actually had some plaintiffs' lawyers who have, if they had the choice between the Eastern and Middle District, have chosen the Middle District, ironically, because it's a case for mediation, and they want to be in our free mediation program. That's a difficult strategy from their perspective, because I think if I was a plaintiff's lawyer, I'd much rather be in the Eastern District. They seem to be a little bit more employee-friendly there, but nevertheless, the federal mediation programs are typically fantastic as well. I'll get a little bit wonky here for a moment, and this is probably more for the insurance folks who deal with claims on a regular basis, and talking about Rule 68, offers of judgment. This is, under the federal rules, there is a mechanism by which you can offer a plaintiff judgment in the case. You have to do this at least 14 days prior to trial. In most cases where we're doing this, we're doing it pretty early on. It's a pretty powerful tool, because what you do is you say to the plaintiff, look, we're going to give you X amount of dollars, and that we're going to allow you to take judgment against us. And If the employee does that, they take the judgment, their attorney puts in a fee petition, and you pay the attorney's fees as well. In some cases, that may actually be cheaper than defending it and paying your own attorney. Even if you win, you may pay less doing something like that. And so in those cases, it's advantageous to do that. The way this tool is powerful, though, is in fee-shifting cases, like claims under the anti-discrimination statutes, Title VII, ADEA, and ADA, fees, if the employee plaintiff rejects your Rule 68 offer of judgment, and then goes to trial and is successful at trial but does not get a judgment that is better than what you offered them at the Rule 68 offer, they can't recover their attorney's fees anymore that were incurred after that point in time when you made that offer of judgment. And so, again, I think sometimes this is a valuable tool to use early in litigation, because it certainly is going to make the plaintiff's attorney sweat a little bit. If they think at the end of the day, wait a second, I might not recover my statutory fees here if my client doesn't have a big verdict. So it's certainly, I think, a valuable negotiation tool in trying to resolve cases. Any questions on settling employment cases? Yes, Ms. Ayala.
I had one. Is it common for a person to stay in a job after a claim is settled?
I see it on your phone. Is this coming from your mother?
No.
Oh.
I just wrote down the question so I wouldn't forget.
Sorry, I should. Miss Ayala's mother, she works with her mother and their clients, and so I thought that was being phoned in from your mom. Is it common for them to stay after a settlement? It depends. Very often, if we are settling a case with a current employee, a resignation is advantageous typically to the employer. It's not required in any way, and that's a negotiating point sometimes. Sometimes an employer would want that. Sometimes the employee would want that as well. I think it's a case-by-case scenario where the parties have to look at it and say, what's best for everyone moving forward from this point? We've resolved this. Can we get back to working together and having a harmonious work relationship moving forward? Or have things been so soured as a result of this that everybody's probably best moving on? And if that's the case, is there going to be a reduction or an addition in fees because of that, because of the way an employee may want to go or not? Yes?
Andy, how do you deal with parties that don't want judgments against them? Okay, by Rule 68.
Yeah, you don't submit an offer of judgment. That's the
Leverage. What's your leverage?
What's that?
What's your leverage with
With my client, because I have that discussion with the client. I say, look, this is a very valuable tool. We can resolve this. This may be a great mechanism to try to resolve this case early. You have to understand, though, this is going to be a judgment against you. This is not a private settlement anymore. This is a judgment. It's going to be public. If there's a publicity angle to it, it's going to get picked up. It's also going to be a judgment on your record. So if you're going to apply for EPLI insurance, it's going to get picked up. This may affect you in other ways. Some clients are okay with that, and some of that is a discussion of what's it really mean. If the public sees a nuisance value settlement entered as a judgment, is that really something you should be concerned about? I think most people would pick that up, and if a newspaper picks it up, they say, "Oh, you settled for $2,000." Big whoop. But the client has to understand that if you do make an offer of judgment, you run the risk that you're going to have a public judgment entered against you. Yes?
What are your thoughts on arbitration agreements?
Yeah. Some people are all in on arbitration in employment cases. I think it depends. I am not a proponent of blanket arbitration agreements with employees. There seems to be this perception that arbitration is employer-friendly all the time. In some respects, it's not. I think in some respects, if you're on the defense side, you have a better chance with the employee having to go through all of the steps, the administrative process where facts are going to come out, the court process where you have formal discovery rules and you get a bunch of depositions and you get the opportunity to do all this discovery. You may end up having a case dismissed on a motion to dismiss if the pleading's really bad, or a summary judgment, and you never have to actually go to a fact finder. You never have to actually get the case to a judge or a jury to decide a fact. Arbitration is kind of quick, fast, and dirty. And so you may go in front of some attorney who's been appointed as an arbitrator. Most of them try to be neutral, but have their own background that they bring to the case. And they sit as judge and jury on these things. And you get limited discovery very often. And so you haven't had the opportunity to develop your case the way you would if it were to proceed in formal litigation. So I offer that as some negatives, because I think far too often employers just want to say, arbitration's great, we can keep things out of the public, and that's great for us, and we'll bury employees. The one advantage I think it has for employers is if in that arbitration agreement it waives class claims. And that was the issue in a series of employment cases that went up to the Supreme Court. There was a Walmart case, I believe in 2016, that addressed that issue. And the courts have generally upheld it under the Federal Arbitration Act and said that is fine. That is certainly, I think, of a benefit to the employer, where the employees have waived class claims and instead have to go through arbitration instead. Much more cost effective to defend cases individually than a huge class claim. Although if you have a whole bunch of employees, especially in maybe a union environment where word gets out that there's an issue, and then you've got to deal with hundreds of arbitrations where you could have just dealt with one class action, you might find that it would have been more cost effective to actually deal with the class action. So I think it depends on the employer and what the employer's motivations are. I would also just not slip it into some stack of documents. I think that has been kind of the challenge. We've seen some pushback, not in the employment context, but in the consumer protection context already on these, where you've got some arbitration provision in some 50-page agreement that you click agree to here, and whether that's going to be held up as reasonable, I think is debatable. Sure, Chloe.
So I know when I was from the plaintiff's perspective, if there's no hard evidence and all they're basing everything on is circumstantial, they hate arbitration agreements, because you can delineate, like Anthony said, how many depositions can be taken. But if you have rules in the arbitration agreement that abide by JAM's rules for arbitration, and as long as you follow certain procedures and I don't know, from a plaintiff's perspective, I think they're more beneficial to an employer, because you just restrict the litigation, the discovery rules. But that's been my experience with it.
Any other questions? All right, again, we're going to take a 5-minute break. Everybody can use the restroom, get some water, coffee, and then when we come back, we're going to talk to Dana Hutter from the EEOC.